Thanks everybody for joining us. I'm Jillian Hadfield, Director and Chair of the Schwartz Reisman Institute for Technology and Society, and also a Professor of Law and of Strategic Management at the University of Toronto. I am really looking forward to this talk today. Before we begin, as always, we want to take a moment to acknowledge the land on which the University of Toronto operates, which for thousands of years has been the traditional land of the Huron-Wendat, the Seneca, and most recently the Mississaugas of the Credit. These and other Indigenous peoples across Turtle Island developed complex and effective governance systems based on respect for all life and the intelligence of the natural world. And today this land is still home to many Indigenous people who are working to reclaim their rights to self-governance. And we're grateful to have the opportunity to live and work on this land. And although we may all be joining from different places today online here, we encourage you to reflect on the history and relations of the land on which you live and work. So a couple of logistics before we get started. Our session is being recorded. Jennifer will speak for about 50 minutes and she'll take questions after her talk. And during the Q&A portion of the session, we encourage you to use the raise hand function in the Zoom meeting controls. They're hidden under reactions. If you feel comfortable turning on your camera, we encourage you to do that for our engagement. So let me introduce our speaker for today. Jennifer Raso is an assistant professor at McGill University's Faculty of Law, where she teaches administrative process and poverty and the law. Her research investigates the relationship between discretion, data-driven technologies, and administrative law. And she's particularly intrigued by how humans and non-humans collaborate and diverge as they produce institutional decisions and the consequences for procedural fairness and substantive justice. Jen is presently exploring these issues as the principal investigator on a SSHRC Insight Development Grant project entitled Shifting Frontlines in the Digital Welfare State, Coding Canadian Social Assistance Laws. Before joining McGill, Jen was a postdoctoral fellow at the University of New South Wales, a visiting fellow at the Yale Law School, Information Society Project, a visiting researcher at UC Berkeley's Center for the Study of Law and Society, and a lawyer for the City of Toronto. And she obtained her SJD from the University of Toronto. So we're glad to have you back, Jen. Without further ado, Jennifer, you can take it away.
Great, thanks, Jillian, for the warm welcome. It's nice to be back at the University of Toronto virtually, I guess, joining you from Montreal. I'm just going to try and share my screen. Hopefully this will still work and then we can get going. Here we go. Okay, perfect. So, I'm here today to, of course, present you with some thoughts about this notion of digitalized administration and specifically the digital administrative state. So today I'm going to present findings from an ongoing study of digital transformation that's been happening within administrative agencies. And as Jillian noted, a lot of my work has centered on social assistance laws, but what I've been finding is that there's actually some really interesting parallels between what's happening in social assistance programs and what's been happening in terms of border security and border governance. So I'm going to present some thoughts about the effects of digitalized border administration on both the concentration and diffusion of power and agency within administrative governance. And of course, I'm happy to chat about the case study that I present to you today, as well as perhaps some of the confluence between what I'm presenting here and social assistance law. So first, I'll introduce you to the context that I'm exploring. So this notion of digital transformation within the administrative state. And then I'll illustrate some of the fundamental challenges that digital transformation projects present for conventional legal accountability mechanisms. And I'll do this primarily by drawing on an illustrative example that resulted in a federal court decision, but my focus will be on the facts of this example rather than what the court did with the set of facts. And then finally, I'll provide you with some of my thoughts about the challenges that this situation creates for conventional legal accountability. And so I will kind of drop some of my own reflections there, but I'm really interested in hearing your thoughts about the arrangements that I describe, and also some of the upshots for legal and other forms of accountability. So first, moving to the context or this notion of digital transformation in administrative settings. So I'm using the paper that I'm presenting you today to explore this subject that sometimes goes underexplored in literature that's been evolving on data agents or data subjects, also literature that's been evolving on human and non-human relations and so on. And really what I'm interested in exploring is this notion of state agency as a central component of what we think of as the administrative state, both central for kind of theories of governance and also for administrative law mechanisms. So in my work, I've been exploring a variety of digital governance initiatives, and these are initiatives that combine algorithmic and data-driven systems, so not just discrete technologies, but whole kind of infrastructural relations that are sophisticated and less sophisticated. And these are very often layered on top of existing bureaucratic settings. So we can see some of these examples that are prevalent and have been ongoing in social assistance programs in Canada and elsewhere. There's also, of course, a variety of initiatives undertaken during the pandemic to provide assistance to individuals that were done largely through online or kind of e-government platforms. And then, of course, there's been an ongoing move to use technology, digital and otherwise, to help manage border crossings, to both make visa decisions, so immigration type decisions, and also to evaluate security risks and identify risky travelers for further scrutiny. So this transformation is something that has been ongoing for a few decades now, but it's really become the focus of governments in Canada and elsewhere. And we've seen especially the creation of what are called digital transformation offices or digital government units, both provincially and federally in Canada. Around 5 or 6 years these agencies have been developing, and they've been engaging in both piecemeal and kind of wholesale transformation of administrative agencies and the tasks that those agencies perform. So when it comes to border crossings and immigration decisions, for example, there's a pilot project that's been happening for a few years now to involves some batch processing of visitor visas from applicants who reside in China and India, and that automatically approves some of these visa applications and sets aside any that look like they require further scrutiny to be reviewed by an immigration official. Similarly, of course, there's a long literature on the use of different types of algorithms and lists to evaluate security and to pinpoint risky travelers in the context of border crossings. And so these digital transformation offices are a recent phenomenon, but they're kind of mapped on or layered on top of things that have already been happening in the administrative state for some time. And this is an international phenomenon. There's similar agencies that exist in the United Kingdom, in Australia, and elsewhere in the world. So through this research, I've started asking questions about what exactly is going on here, and really trying to set aside some conventions that are becoming more established in the literature about how we think of the relationship between human officials or human decision makers and technological tools. And as I've been doing this, I've started to perceive a phenomenon that that is this topic of this paper that I'm presenting to you today. So this phenomenon I describe as follows, that where we have digital transformation occurring within administrative agencies, it seems that there's a simultaneous focusing in of state power, so state agency and authority being kind of zoomed in to center on particular individuals, and that this has significant effects, of course, for the people who end up being the subject of that scrutiny. But at the same time, in running in parallel, there's this diffusion of state agency and responsibility among many different agencies within the state and also across non-state or private actors. So this phenomenon isn't itself necessarily new, and it's not necessarily something that can just be traced to the digital state. So for example, in socio-legal studies, Saskia Sassen and Mariana Valverde have both examined how state authority spreads out through mechanisms like public-private partnerships and other relationships between local governments all the way up to federal governments. And in administrative law, of course, Carol Harlow and Robert Thomas, who are public law scholars in the United Kingdom, have both been doing a lot to question the usefulness of a public and private divide, specifically where state services have been contracted out for a number of decades now, in the UK in particular. But I argue that there's something of a different quality that's happening with the advance of digitalization projects. And perhaps this is linked to the changes in administrative or bureaucratic culture that has gone along with these projects. And I don't think that this phenomenon can entirely be explained by literature that focuses on procurement or contracting out, because in some cases, the spreading out of agency is happening across state agencies themselves. So it's not a wholesale diffusion of agency to private actors and an abandonment of state actors' responsibility, but that we see this kind of spreading out within different administrative agencies themselves. And as I'll explore in this paper or in this presentation today, this spreading out is accompanied by what I've already described as this kind of intense focusing in of state power on particular people, and oftentimes on the same people over and over again. So in digital border contexts and elsewhere, these are the people who have features that are regularly identified as being risky or dangerous or in need of further policing and scrutiny. So this can be tourists who don't have a citizenship status in the place that they're traveling to. It can be irregular migrants, members of racialized communities, trans folks, and many others who are involved in border crossings, who may be involved in receiving social assistance, who may be singled out for further scrutiny by policing agencies. So I come to this topic and this phenomenon as both a socio-legal scholar and an administrative law scholar and a former administrative lawyer. So with my legal hat on, I have lurking in the back of my mind questions about legal accountability and other forms of accountability, responsibility, fairness, and substantive justice. But as a socio-legal scholar, I'm also thinking that it's essential to examine the mechanics of what's going on here. In other words, to really scrutinize the terrain or the contexts here to get a better sense of how decisions are being made, how authority is being enacted and pushed around, because I think that those insights are important ultimately for understanding how administrative law and other accountability mechanisms might evolve to better apply to this digital state that I'm describing. So I'll explore this topic today, drawing on an illustrative example that I have taken from a recent federal court case. And this example is one where we have an individual who has a pre-approved visa status and who tries to enter Canada. And I use this example as what I would call a catalyzing moment in digital administration, where we see this paradox of the concentration and simultaneous diffusion of state agency very clearly. So this example centers on Canada's border control and immigration procedures and laws. And so I'll provide you with a little bit of a snapshot as to that type of a background, and then I'll get into the details of the example itself. So in Canada today, of course, tourists who visit the country in many cases receive pre-approved visas before they actually set foot in Canada. And these visas, which are called temporary resident visas, are issued by the Immigration and Refugees and Citizenship Canada agency, or IRCC, which is much easier to say, less of a mouthful. So these visas involve an assessment as to whether somebody is legally eligible to enter the country. And if that assessment is positive or in someone's favor, then typically they're allowed to remain in Canada for a period of up to 6 months. Now, people who wish to visit Canadian family members who are not citizens or permanent residents or asylum seekers in Canada themselves may apply for what's called a multiple entry visa in order to engage in trips back and forth to visit their family. And so this multiple entry visa is something that's especially offered to folks who are coming from global south countries, and is something that involves a pretty extensive application process. So these individuals must submit documents online, including a proof of income and an attachment or a deep attachment to their home country. They also must supply proof of the relationship that they have with the family members in Canada. They may be asked to provide medical reports, a photograph of themselves, fingerprints, and other types of biometric information. And these documents are then reviewed by visa officers who work for IRCC. And if the visa is approved, then the paperwork is sent. But of course, this paperwork is digital, so it's sent by email. And then once it's received, individuals can book their travel to Canada. Now, airlines, of course, require this type of visa pre-approval to board a flight in most cases, in addition to the requirement that the traveler has a valid passport. And when someone with one of these multiple entry visas arrives in Canada at an airport, they still need to be evaluated or interact with an official. So this person in some literature is described as an immigration official, but usually it's actually a border official. In other words, an employee of the Canada Border Services Agency, which is a separate administrative agency under the control of a separate minister as compared to the IRCC. And that official asks additional questions of the traveler. And these questions are aimed at determining whether this individual is admissible to Canada. So in other words, do they appear to pose a risk to security, including a risk that they might overstay their visa and stay past the 6-month timeline. If everything goes okay in this interaction, then the traveler will gain entry to Canada. And this, of course, is an important administrative decision. If things do not go well, then the individual will typically be refused entry and will be boarded on the next flight back to where they came from, their home country, in most cases. So now turning to the case study in question. So the case that I have centered my analysis on for this paper is a case that involves an individual, Mr. Smail Kanish, who was a citizen of Algeria. Now, he was a railway mechanic in Algeria and had a wife and 2 young children there. His brother was a Canadian citizen and still lives in Montreal, to my knowledge, but works remotely in Fort McMurray, which is, of course, a common Canadian experience. Now, Mr. Kanish applied for and obtained a multiple entry visa so that he could visit his brother more regularly in 2017. And he completed 1 trip on that visa. In 2018, he booked a second trip and he purchased his ticket in cash, which was the only way to make the transaction where he was located at the time. And he boarded his flight in Algiers. When he arrived in Montreal at the airport here, he was interviewed by a border official. And he explained that he was going sightseeing with his brother, that he wasn't sure exactly where they would be going sightseeing. He also explained that his brother lived in Montreal, but worked in Fort McMurray. And this seemed to perplex the officer who, according to the account of this interaction put forward in the litigation, started to frown and look at his computer screen. Now, Mr. Kanish then offered to call his brother to verify the story, and his brother was waiting just outside the terminal in the arrivals area, but the officer refused to receive this additional evidence. Instead, the officer demanded that Mr. Kanish hand over his cell phone and his password to the cell phone, as well as his passport, his airline ticket, and other identity documents. And the officer said to Mr. Kanish, "You're doing pretty well in your country. Why did you really come to Canada?" He then ordered Mr. Kanish to be quiet and called the airport police. So these are Montreal city police officers who work at the airport. At this point, he told Mr. Kanish, "Tonight you're going back to your country." Then the officer pushed a voluntary departure form in front of Mr. Kanish and instructed him to sign the form. Now, Mr. Kanish refused to sign this form, and the officer attempted to physically force him to sign the form by grabbing his hand, but was unsuccessful. And then the officer and airport police escorted Mr. Kanish to the same plane on which he arrived, and he was boarded onto this plane, and his documents and phone were returned to him by airline staff. And he returned to Algeria the next day. The officer then typed a series of notes into the global case management system, which is a digital record-keeping system used by IRCC, the Canada Border Services Agency, and a variety of other partner agencies as they're described in government documents. And this system does a number of things. Primarily, it stores information about visa applications, past decisions, traveler information, and it performs some other types of screening functions. But it also acts as a tool that allows coordination between a number of different government agencies. The officer's notes stated that he didn't believe Mr. Kanish was a true visitor to Canada or that he would leave the country. And the notes, which were provided in the course of the litigation, indicated a number of risk factors that supported the officer's conclusion. So these are common risk indicators that will be familiar to anyone who studies border security. For example, Mr. Kanish was an Algerian citizen, which already places him at high risk. He bought his ticket in cash, and the ticket amount cost the equivalent of 1 month's salary from his job in Algeria. He had no hotel reservation. He didn't know where he would be sightseeing, and so on. And at the end of the notes, the officer wrote that Mr. Kanish failed his security screening and that he was allowed to leave Canada. So no information in the notes about the forcible denial of entry and boarding the plane, but rather a permission to leave the country. So this case, of course, was one that proceeded to be litigated at the federal court, which is extremely rare for this type of decision-making to be challenged in this way. But for me, it's of interest not because of its legal implications or what the court decision stands for, but because the facts of this case and some of the reporting around this case illustrate that paradox that I suggested earlier, one that's becoming increasingly common in digital administration. So I'm going to turn to that paradox now to unpack it for you using the facts of this case. So this paradox of the focusing in and diffusion of state agency creates some real challenges for legal accountability, specifically in administrative law. So administrative law typically allows or enables certain types of redress or remedial processes to become available when a decision is made by a state agency that affects an individual's important rights or interests. So the ability to cross a border into Canada and decisions that limit that ability are understood to be one of these types of important decisions. They affect someone's legal ability to enter the country. And indeed, of course, as I've noted, Mr. Kanish did challenge this decision to admit him through litigation at the federal court. And in the example I've just described, of course, we have a focused form of state power. So we have this state power directed and experienced quite viscerally by Mr. Kanish. So you could think of how the state power in this image that I have here, which is a photograph from artist Jenny Rainbow, kind of focusing in and pinpointing Mr. Kanish as somebody who is a target for further scrutiny and eventually for removal from the country. So we have this focusing, yet at the same time also this diffusion or dispersal of agency among many agencies and other actors that creates a real challenge for administrative law, both in terms of the way administrative law conceptualizes responsibility and also functional challenges that I'll get into in a minute. So in terms of the focusing in of state power on Mr. Kanish, of course, we have a situation here where Mr. Kanish is scrutinized. He undergoes significant questioning. His cell phone and other documents are seized and accessed. Attempts are made to have him sign a voluntary consent form, and he's eventually physically removed to the plane and sent back to Algeria. And these forms of state action that are the result of an algorithmic or digital system singling somebody out for this type of treatment are increasingly being described as forms of algorithmic violence by Rocco Bellanova in Europe and other scholars. And this literature really, I think, is developing because of the intensity of these interactions that are becoming kind of common occurrences for people, not just in border crossings, but in those many other digital administrative contexts that I've described earlier. So the officer's notes as well participate in this type of focusing in. Those notes that are recorded in the global case management system focus the state's attention not just on Mr. Kanish in this moment when he's being scrutinized and ultimately removed from the country, but they also create a situation where further state scrutiny by Canada and perhaps other states will necessarily follow because Mr. Kanish now has been identified as a risky traveler. And the other partners that federal agencies in Canada share these notes with very likely will have access to some indication that Mr. Kanish has been identified as a risky subject. It is also possible that there are other mechanisms or other tools that may have been used in this case to flag Mr. Kanish as a risky subject, but of course those are not accessible to folks like me or even easily accessible to Mr. Kanish. But if we focus on Mr. Kanish and imagine him searching for the agency of the state or which agent of the state is responsible in this case, we find a diffusion of agencies and actors that contribute in material ways to the ultimate outcome. And many of these actors will be familiar to anyone who studies border security. So for example, airline staff act as state agents or on behalf of the state when they vet visa and passport documents before somebody boards an international flight. They're also involved in helping get Mr. Kanish on the plane and sending him back to Algeria. We have, of course, a municipal police force that's providing additional security services in the airport on behalf of the Montreal police, but really enforcing or supporting the decision of federal state agents. It also seems clear that there's some sort of algorithmic risk analysis that was used to inform the officer's interaction with Mr. Kanish. So perhaps something that is connected to wider international risk assessments about travelers who either are at risk of overstaying visas or perhaps pose greater security risk. This is quite possible. It's not outside the realm of reasonableness to assume that that is something that's happening as well. But there's also this diffusion that happens within and across state agencies in this example. And this is important for conventional notions of accountability in administrative law, and also for broader notions of agency or responsibility. In other words, who or what is responsible for this decision on behalf of the state. So, for example, there's multiple federal administrative agencies that contribute to the outcome that affects Mr. Kanish. His interaction seems mainly to be between himself and Canada Border Services agency officer, as well as the software that that agency interacts with. But it's, of course, IRCC who issues the multiple entry visa and who manages the visa approval process. And the Federal Treasury Board as well is involved in maintaining and updating the global case management system technology, including oversight, of course, under the Federal Directive on Automated Decision-Making, and more recently, a renewed interest in further revolutionizing this tool. So presently, the Treasury Board is spearheading a digital transformation of the GCMS and of the visa application process itself. Now, why does this matter? So sure, it's interesting mapping all of this accountability out, but what's the upshot for legal accountability and other forms of accountability? So this diffusion that I've described has practical implications, I argue, for legal accountability, specifically for naming a responsible agency, and also for the phenomenon that will be familiar to any administrative lawyers out there of buck passing. This is not a technical term, of course, but it's something that's commonly observed in administrative agencies. So first, getting to naming. Of course, in administrative law, like in other areas of law, in order to seek redress or remedy against an individual or an agency that has made a decision that affects your important rights and interests, you must name the agency or the ministry or the minister that's responsible for that decision. And this is, of course, something that happens in court proceedings, but it's also important for any type of tribunal challenges that might be involved in holding the many federal agents involved in this decision to task. So here, interestingly, Mr. Kanish's lawyer, who is actually an expert in immigration law, initially named the wrong ministry. They named the minister responsible for immigration and citizenship because, of course, this seemed to be a decision that centered on Mr. Kanish's visa. And through the process of the litigation in this example, that name had to be changed to the minister responsible for the Canada Border Services Agency. So that's the Minister of Public Safety and Emergency Preparedness. But of course, from both a legal and a practical perspective, is naming one agency enough? Typically in administrative law, this is what happens. You name the responsible agency, but in this case, there seem to be multiple, at least 3 federal agencies involved in or contributing to this decision in some way. So in other words, if Mr. Kanish's legal team were to try and dig deeper to name the entities responsible in some way for his removal in order to receive a remedy against them, or even in order to play a symbolic role in calling them out for their actions, they would have encountered real challenges due to not only the diffusion that I've just described, but also this practice in litigation itself of requiring this focusing in on one particular agency. Turning to the buck passing issue. So in this example, there are a number of different types of buck passing behaviors that are at play. So first of all, the government officials that were involved in this case, including the lawyers who represented the minister in question, deliberately tried to pass the buck during the court challenge and even during the encounter with Mr. Kanish himself. By this, I mean, it was argued that Mr. Kanish consented to withdraw his request to be admitted to Canada. So in other words, that this form that was placed in front of Mr. Kanish was something that he somehow agreed to the contents of the form, which would have indicated that he decided against entering Canada and that he returned to Algeria of his own free will. This was unsuccessful ultimately in the judicial review litigation. And of course, it was also unsuccessful when the officer provided Mr. Kanish with the form, which he refused to sign. But perhaps it's indicative of the thinking of officials in this case and even government lawyers in this case, and might suggest why the CBSA officer wanted Mr. Kanish to sign the form in the first place. Doing so would have, in the official's view in this case, basically vitiated Mr. Kanish's application, and ultimately would have been an indication that there was no decision made at all, because there wasn't an application to cross the border. So then there could not be a decision to be made on that application. So these were the kind of circles that the government lawyers and officials were spinning in this litigation. In addition to that type of kind of complicated buck passing to Mr. Kanish himself, there's also a broader kind of infrastructural support for buck passing among different agencies that is evident in this case. So the technologies like the global case management system and other tools are, of course, designed and created to enable information sharing between different government agencies, or even collaboration among different partners. And Canada, like the United Kingdom, the EU, Australia, and other jurisdictions, continues to build a global border governance infrastructure that is at least partly grounded in these types of tools, as well as in more advanced kind of risk analytic tools to share insights across jurisdictions. And this infrastructure relies upon this interchange, not just between agencies within Canada, agencies outside of the country, but also interchange between different data systems and data sharing between those public and private actors that I've described. Many of these are, of course, state agencies, and others are what we could think of as agencies that are acting on behalf of the state in some way, such as airlines. Now, when this system is layered on top of an already complex bureaucratic system, specifically the immigration and border security arrangement in Canada, this technological infrastructure and the expanding web of relationships that it allows for may magnify the type of buck passing that already happens within administrative agencies. So there's a long, fascinating literature sometimes under the heading of the anthropology of the state, that examines how bureaucrats creatively dissuade people from targeting them as the responsible agent, and will often point to others within their office or perhaps their superiors who are the responsible ones, perpetually kind of pushing off their own authority and the important role that they each play in a wider bureaucratic system. And so my observation is that these types of tools and digital transformations actually allow that buck passing really to multiply, both between agencies, between people and technologies, and even internationally among different jurisdictions. So if Mr. Kanish, again, were to try and seek a legal remedy against all of the agents responsible for the denial of his entry into Canada, where would he even begin? we might ask if this approach to claiming that is one that is foundational for administrative law is frustrated by the kind of buck passing that we see happening in this example and in other settings. And this is particularly concerning for administrative law, of course, because administrative law mechanisms are conventionally very deferential to administrative decision makers and occasionally continue to rely quite heavily on this division between public and private. So carving off kind of the core state agents who are responsible and allowing for others who are perhaps at arm's length to not be responsible through administrative law mechanisms, at least. What other effects exist? I think in addition to these challenges for legal accountability, there's a really important practical upshot for administrative justice or even good government. So this focusing of state power seems to be intensified through the kind of collaborative teamwork between multiple state agents and between those agents and the technologies that allow for this coordination. But this collaboration has lasting effects for Mr. Kanish and others like him. This diffusion of authority and agency that I've described is not only widespread, and it's not only of interest, I think, from an academic or a legal perspective, but it should also be of interest and concerning to anyone who is keen to support trust and trustworthy state agencies. The devastating consequences, rather, that this type of focusing in and diffusion has for people like Mr. Kanish are quite important and quite crucial. For someone experiencing this type of situation or any other situation where digital government either refuses benefits, creates an erroneous that targets them for increased policing, it's like being stung by a swarm of bees that appear to be in the form of some sort of state agency or perhaps in the form of a digital interface, a website, and so on. But when one takes a swing or tries to challenge the swarm that's stinging them, they end up finding that the swarm changes shape, changes form in ways that make that type of swinging and searching for accountability in many cases frustrated. The result of all of this, of course, is that people who are impacted by these initiatives and others who can see what's happening, I would argue, may end up punching the air while the bees keep stinging. And I think that this phenomenon is one that needs to be taken seriously, both by scholars of law and technology and others, because it's not just a phenomenon that can be linked to the relationship between humans and non-humans making decisions. It's not just a phenomenon that can be addressed or solved by looking behind or within the black box and scrutinizing the algorithms that are at play, but it's a qualitative shift in how governance is occurring today. It changes relationships between the public and the state in ways that fundamentally upset and destabilize trust in government. And I think that that's an issue that requires further scrutiny and ongoing analysis by scholars here and in the wider academic and legal work. So thank you for your attention, and I'm happy to take your questions.
Great. Thank you, Jen. That was great. Maybe we'll stop the share. There we go. And we'll turn to some questions. Yuxing, have I got you correct? Good. Go ahead.
Thank you, Jennifer, for the very rich and thought-stimulating talk. So I have two related questions. So as you mentioned, as many different types of organizations now provide public services or build, public works without being strictly speaking, part of the government. So as you mentioned, the actual work of public administration, including board administration, is becoming increasingly fractured. And this complicates conventional accountability mechanisms. So my first question is, before we start thinking about a new paradigm of accountability measures, we probably need to perhaps start by asking what the role of algorithms really is in the process. So should we really approach these systems as a persuasive source of evidence, or it is an additional layer of decision-making support tool alongside the human decision makers? So I wonder, what is your take on this, and how can different ways to conceptualize the role of algorithms or these digital tools give rise to different doctrinal shifts and accountability measures? And my second question is actually related. So the point you raise is a very interesting point you raise is about how the digitization process, spreads out the agencies and responsibilities. And many of the existing design justice paradigms principles, they tend to focus on the notion of transparency or the need to adapt an intersectional approach to system design. So I wonder, from a legal perspective, if you see the overall digitization process as posing some fundamental challenges. So one is bug passing, as you have really analyzed. Another is perhaps, maybe in theory, each step might have followed procedural fairness or certain design justice principles, but their multiplication, or when these subsystems work together as a whole, they might still bring about some systemic injustice, especially for those who are intersectionally disadvantaged. So I wonder, what is your take on this? Thank you.
Should I answer that question, Julianne? And then
yes,
okay.
you can
Perfect.
answer each one in turn. Yes.
Okay, wonderful. Yeah, thank you for those really excellent questions, Yuxing. So these are things, of course, that I'm still thinking through, and so I don't necessarily have I think kind of the answer at this point, but I have some intuitions that I'm happy to share. So perhaps going to your second question first about what other challenges might exist that perhaps aren't captured in the design justice approach. I think that what you've identified is exactly the problem. So in other words, sometimes design justice or other approaches that are focusing on technical bits in isolation, or even approaches that are focusing on the decision makers or the humans in or on the loop, however they're conceptualized, are not necessarily thinking about the wider kind of agency context in which decisions are being made. And this is one of the, I think, things that needs to be investigated further. So there's some folks who are writing from kind of an infrastructural regulation, infrastructural design standpoint, who I think are more interested in mapping out what's happening with an understanding that knowing how different components of a larger decision-making system interact is crucial for understanding what might be possible in terms of legal accountability mechanisms. But it doesn't mean that that individual focusing in on the discrete components is abandoned or it doesn't matter. I think that what that system level or infrastructural approach does is it really allows us to get a fuller perspective of all of the different components and their interactions, because sometimes that can be lost when we're zooming in on those individual building blocks. So I think that's an ongoing challenge, both for folks who are researching in this field, for lawyers as well, because it certainly in many ways butts up against the conventions of administrative law, which itself focuses in on at least like one responsible agency. But it's certainly something that I think needs to be engaged in because of the stakes being so high and the impacts already being felt by so many people. So thinking about algorithms and the role that they play, I think that depending on how you envision algorithms and their function, like whether they're a source of evidence, whether they're a decision-making unto their own right, really affects the type of accountability measures that would be proposed. And so you can see some of this reflected in how the federal directive on automated decision-making operates, where there's this categorization of algorithms into kind of high and low risk categories and different types of scrutiny that mostly focus on procedure that are placed on those algorithms based on how they're categorized. And so that sees algorithms as a kind of process tool and imposes on them a certain type of notion of procedural fairness that I'm still thinking about, but that allows for, requires some sorts of fairness in some situations, and then kind of anything goes in the low risk categories. I mean, this is my take on the directive, but it's quite flexible. And then of course, non-binding, it's just a directive, and there's already many reports of different tools that didn't go through an impact assessment and so on, such as facial recognition being used in airports. So, so yes, I think that really thinking about this relationship between how we imagine algorithms to function being intimately linked to what we do about them is important. And again, it's not to suggest that algorithms can't do many things at once. In many cases, they're both a source of evidence, a decision maker, a tool that streamlines kind of the management of an office. So in that way, they can be a managerial tool. They can allow for auditing of decision makers by outside officials. So in that way, they're also a tool of kind of managerial governance within a bureaucracy. And so I think it's important to be conscious of all of these different capacities for these tools, because it then allows for, I think, a better, maybe it's humility, maybe it's strategic thinking about not just what's possible, but also what's important when it comes to regulating or designing these tools.
Okay, thank you. We'll go to Jamie.
Awesome. Thank you so much, Professor Raso. That's a really fantastic presentation, and in particular, thanks for bringing this really interesting case to my attention. And my question sort of revolves around some of what happens in this case. I find the framing of naming and buck passing really helpful. And when you've published this paper, I'll most certainly be borrowing that. But my question sort of revolves around this ambiguity around the use of algorithms that you were mentioning, because I went and looked through the case and like I can't find any mention of it. But we know that the CBSA through the National Targeting Center is processing advanced passenger information, passenger name record information, which is how, for example, they knew that he paid for his ticket in cash. And because of sort of the standard of evidence that a CBSA officer has to provide, sort of have to meet the standard of like reasonable suspicion, it seems like they chose not to disclose how algorithms factored into this decision when this came into court. And so I'm wondering if you could fill in some of the gaps and the impacts of this this ambiguity, or the fact that they can kind of opt out of disclosing how they've made their decisions, and what's the upshot of that might be.
Yeah, so I think this is one of the perpetual challenges. And like, I think if you were to view this case from the perspective of the CBSA officer that writes the notes, or if you were to read ethnographic literature by Anna Pratt and Vic Satchowicz and others who have studied how officials go about making decisions and writing notes that are understood to be the ones that will survive judicial scrutiny, you can see how the language that's used does indicate the things or the sources of evidence that the officer considered. And it goes through the standard list of, no hotel room, ticket paid in cash, et cetera, et cetera. But the source of that information seems to be partly Mr. Kanish and partly somewhere else. And I think that there is an underlying suspicion here that is made reasonable through the notes, but that perhaps is buttressed by this additional data sharing infrastructure that's like almost certainly supported by that infrastructure, but that isn't required to be disclosed through the notes themselves. And so I think that if you're interested in like the role of reasons in administrative decision making, the importance of disclosing all of the sources of evidence that are relied upon, that's an important question to be asking. And I think that one of the challenges here from an administrative law perspective is that while this is a high stakes decision for the individual in question, it's unclear to what degree a reviewing judge would require all of those things. And because administrative law is so reliant on what judges say about what's required in particular circumstances, unless there's additional moves made by legislators or others who want to impose those standards from the outside, or from the inside really, through other legislated accountability mechanisms, it's unclear how the practice would change. So that's not to say that it can't change. Like realistically in this type of situation, one of the ways that change can be achieved quite quickly and dramatically is through managerial changes. So, what are the policies that apply? What type of a review do managers have of the officials in question? What other types of internal accountability exists? And is there a reason to be pushing in that sphere for this new type of practice to disclose all of the sources of evidence? But from an administrative law perspective, what you might see happening if someone wanted to just turn to the doctrine and say, what does the doctrine say? They might say, well, this isn't a judicial decision. This isn't a situation where, where somebody has a right to disclosure. Like they would, you could see people getting very technical about what's required by the law and look to case law, which is very sparse in this type of setting. To support that conclusion. So you can see how that in itself, like that type of black letter law approach to the question could be a significant challenge to overcome. But it doesn't mean that it's not important to be pressing for those types of changes. Yeah, I'll leave it at that, but I'm happy to continue the discussion.
Great, thanks very much. Okay, we'll go to Dr. Edmund Beach, recently crowned.
Right. You'll have to excuse me. I'm both 5 hours or so ahead of most of you and sick, so I'm not at my best. Have a somewhat open-ended question that I think your response just now helped clarify for me. I'm thinking about the kinds of continuity and discontinuity that you're uncovering in your work here. You talked about the officer's activities as sort of exemplifying a kind of managerial control, which just makes me think, well, how is this different from memos and files and all of this kind of previous work? But to put it pointedly, I remember Baker, and I'm sure you remember it better than me. I think the officer's name was Lorenzo in Baker, and we have his notes, whatever his name was, his notes are in the Supreme Court decision. And I can't think of anything that would feel more like being attacked by bees than being beset by that sort of just random caps lock assault of one after another, just random sort of probably racist observation about the person that doesn't fit into any kind of algorithm or any kind of, clear. So, I mean, when I think about that, as what we had before. They're probably not the best example. I wouldn't claim that it was necessarily representative, but that was the pathology before. Is this so much worse? And insofar as this is also a bad case, the case you have, was it the algorithm that made it bad? It seems like the officer probably would have been Officer Lorenzo in the 90s without an algorithm, and now he has an algorithm, and I'm gendering him. It's probably, I'm confident about that. Now he has an algorithm, and he's doing the same thing Officer Lorenzo did in the 90s, and the problem is not. Anyway, I'm putting it too strongly, but anyway, this was what I was wondering about, and I hoped you could clarify for me.
Yeah, no, that's a great question. So I think the Baker case is really fascinating, partly because it already signals this kind of fracturing of responsible agents within one state agency. So we have two visa officers in that case. One's a senior officer, one's a junior officer. Officer Lorenz is the one who writes the very shocking notes, really laying it out, saying what he thinks about Ms. Baker and her request to apply for permanent residency status within the country, and also his thoughts about, whether she's going to make valuable contributions to Canadian society. And then you have Officer Caden, who receives that information and is the signatory officer on the letter that goes to Ms. Baker, telling her that her request for humanitarian and compassionate treatment and an exemption from the regular rules that would require her to apply from outside Canada, that request has been rejected. And so here, I would say, I think that the algorithm isn't officer. It's not the, I don't think the officer here is Officer Lorenz. I think the officer is Officer Caden. So I am suspicious of how much of the kind of independent judgment is exercised by this individual officer in the face of very likely strong suggestions from a variety of different risk assessments tools that he has access to that indicates that Mr. Kanish is going to be a risky person to admit to the country. In other words, that there are all of these different characteristics that put together kind of bump him up into a high risk category, and that the officer in this case has very little choice but to kind of rubber stamp the decision. So this would be one way that some scholars would look at this case, and they might say this is very likely a case where we have automation bias. Automation bias being very kind of broadly described phenomenon. I don't think that that's necessarily true. I think that this officer is contributing to the decision as well in the assessment of the risks, but we don't have access to the screen that was in front of him as he made the assessment. We can't see the different risk indicators that very likely would have been very persuasive evidence to him. And of course, he doesn't do the thing that bureaucrats do in other settings, which is turn the screen around to Mr. Kanish and say, look, I can't admit you because of the security issues very likely that would arise and the practices that are or aren't common in this setting. But I would tend to think of him more as Officer Caden, in the sense that there's a tool that is at least gathering information, assessing that information, the information about Mr. Kanish, about his travel history, about how he paid for the ticket, et cetera, and is also doing a bit of assessment himself when he's doing that in-person interview. It's not like he doesn't have a discussion with Mr. Kanish, but to what degree is the mind made up? This is, I think, the question. And I think this is one of the reasons why people who are concerned about accountability, like real accountability in these types of situations, are very suspicious of efforts to just put a human together with an algorithmic tool and say that solves all the problems, because algorithmic tools and all of the managerial pressures that come with them very often are very persuasive, very they exercise their own force, in other words. And so I think it's difficult for officers or other officials who are working with these tools to depart from the tools, particularly if they're pressed for time, if they don't know how to do that, or if they just don't care, right? So this is why I think focusing on the culture within the administrative agency in question is an important but often kind of underappreciated piece of the puzzle, because I think that does go a long way to better understanding and possibly changing how decisions are made in these contexts.
Anne, I see you have a question from the chat. Can I just do one quick follow-up with just on this? Because I'm also not seeing how this case demonstrates the, that we have a transformed environment because of digitization and I mean, of course, we've got algorithms all the way through, and we've had them on pieces of paper and checklists and so on as well. So I think you're presenting a story about the digitization or the use of fancier computer techniques in those algorithms. So I'm maybe I can just push you a little bit more on. So what are we seeing from this case? And maybe that's not the way you were intending it to be, but I heard in Jack's question, what's changed from the 90s? Because I'm not quite hearing that. I'm not quite hearing. I can think of where it might go, but I'm not quite hearing why this case, and maybe we just don't know enough about, I just don't know enough about this case. I haven't read it. So can you say anything just to, why does this case tell us the environment is changing?
Yeah, so I think that the thing that this case does is suggests all of the additional actors on top of the algorithm that are also central to the making of the decision. And in the Baker case or in the 1990s, it's not that those actors didn't exist, but I think that the way that they were networked together was not quite as strong. There wasn't as much data sharing among them. And there wasn't as much reliance on, I think, evolving databases and risk assessment tools as there is today. In other words, kind of the speed at which things might shift under one's feet, as they did for Mr. Kanish, wasn't really present. And I think that as we see states increasingly try to push border decisions away from their physical borders, specifically, which is happening worldwide in response to different migration trends and so on, there's an increasing use of additional authorities, whether they're state agents like the visa officers outside, or those airline officials or others, private security agencies in terms of patrolling the borders of the EU, for instance. So I think it's this kind of ramping up, and it might be just a few extra agencies here and there, but it really is something that is having this, I think, quite dramatic shift in terms of like additional sources of information and also additional responsible actors. And what I would say is that administrative law already doesn't do a good job of conceptualizing or even admitting that a decision is produced by anybody other than the minister. If you look at like the fiction of kind of the minister is responsible and then authorities delegate it down. In Baker, for example, who made the decision? Was it Officer Caden? Was it Officer Lorenz? That issue isn't really tackled by that judgment, and it's not something that's very central to much administrative law scholarship here.
Right.
But what I'm saying is that with the addition of even 2, 3, 4 additional agents, not only does it allow even wider kind of pointing of the finger, oh, it's not me, it's all of these other actors, but it also just kind of amplifies that challenge for administrative law that was already present. So I think it's just kind of this scaling up that is of concern.
Yeah, and I do think there's an analog. So like I said, you can think about just think about autonomous vehicles. We just increased dramatically the number of actors who are engaged in pieces of the process that generates an outcome. And so there's that. I do think that's a generic thing that's coming from approaches to optimization, and the idea, oh, look, we can feed all this data in and produce better models, but that also, you're pointing to, it introduces a lot of other actors into our accountability scheme. Yeah. Very nice. Let me go to Anne. Thanks for waiting, Anne.
Thank you, and thanks for taking my question. It's a fairly basic question, but an interesting one nonetheless. But I wondered, to what extent the algorithmic bias is actually confined to individuals, or whether it's affected by sort of geopolitical relationships that pertain at the time. And certainly in a contemporary setting, we've got US Patriot Act, we've got since 2015, we've got our own Anti-Terrorism Act. And coupled with that, you've got sharing of information as well. So I'm just wondering to what extent the first flag, whether that's at the individual level or whether the first flag is actually affected by state-to-state friendships.
Yeah, I think that it's more of a systemic issue. So while these decisions are made about a specific individual who presents themselves to a border officer seeking admission to Canada, certainly the country of origin plays, I think, a significant role in identifying who's going to be the one that's going to stay past the 6-month mark, and even in increasing certain types of scrutiny that are placed on that individual. And that's not something that is unique to Canadian border decision making, that there are, I think, global trends in terms of identifying people coming from different parts of the world as being kind of higher risk travelers. I think that one of the factors that kind of increases this phenomenon and makes it more concerning is that you kind of have a runaway train when you have one nation or another identifying a third nation as the risky place from which people are coming from, and then others kind of jumping on the bandwagon, and that risk assessment being reflected in their tools then, and then kind of spreading throughout. So I think that that's an additional challenge, and trying to kind of get a hold of that or figure out how to govern that type of phenomenon is another real tricky issue.
Great. Thank you, Anne, for your question. Thanks, Jen. And Amy, I think you're going to get our last question today.
Hi, thank you very much, Dr. Raso and Gillian Hadfield. Yeah, so it was years ago, actually. I went to this conference, and there were a number of public interest kind of litigators from the US talking about, this was the early days of algorithmic decision making in relation to state. I forget if maybe it was housing, and they were suggesting to us, test case type people, that we should ask for disclosure of the assumptions that are built into the algorithms, and so that you could take those apart as well as part of challenging the decision. And I think that remains and will remain really critical to scrutiny of the legitimacy of these decisions. I have since not heard talk about that at all. It seems that, fast forward in time, and we all accept that, these algorithms are programmed in fair ways. I mean, they're just replicating cognitive processes that we could do. And it's really about more so about the assumptions often than the way something is calculated.
Yeah.
What are your thoughts on that?
Yeah, so I think that's an ongoing issue. And I think one of the issues built into it is that when you're asking the people who are developing these tools to, if you were to ask for them to disclose their kind of assumptions or biases, there are a lot of assumptions that are industry standard that are not ones that that they would think of as assumptions or biases in the first place, right? So by that I mean, the expectation that you can have an accurate answer to a question that might center on behavior, for instance, is one that's deeply puzzling to anybody who studies social science. And yet folks who are building predictive tools that purport to be able to predict certain types of behavior, and who rely on indicators that that behavior is likely to occur, such as, increased contact with police, as an indicator that somebody is then likely to, be a criminal. And that's how the tool gets advertised, that the, increased risk of criminality because somebody's having an interaction with a police officer. And that's the data that's used to then do that type of predictive decision making. That construction of the problem and that reliance on that type of data is something that for some who are developing these tools, they might give some caveats as to, well, the tool can't do X, Y, and Z, but many of them will also say, well, this is an accurate prediction of X. And that way of thinking about the problem ignores, of course, what it means for different communities to have a tool like this used for them. And it ignores what folks who study over policing of racialized communities, specifically Black and Indigenous communities in Canada, know about that phenomenon, right? But for people who are just looking at kind of data in a technical way, perhaps, maybe that's something that's not a part of the way that they're thinking about what they're doing. And so they might not even think of that as being a bias that they need to disclose, if that makes sense to you. So I think that there are some deeper questions to be asked about how this type of disclosure would be possible. And also, I think about whether or to what extent collaboration within the teams developing these tools and the input of folks with this additional insight, whether it's social science insight from administrative law, human rights law, and so on, would actually be valuable. Getting back to the first question about design justice, in order to ensure that tools are designed in certain ways, and also in order to ensure that perhaps tools that purport to do something that's not possible are not designed in the first place. For instance, like if there's some people who are very critical about the ability to predict any human being's behavior in the future, and I think with good reason. So I think that there's important questions that should be asked at the design and conception stage about those types of tools that might not be asked by the developers themselves.
And that's a great point. Sorry, Amy, we're going to have to wrap up here. But it's a great point to end on, because I think particularly the goal for our institute is sort of having the interdisciplinary conversation, so that in fact we have a much broader variety of brains and expertise, and thinking about, as you say, the early design phases. What are the implications for legal accountability? It's not purely a technical question about predicting a variable. So a really helpful place. Thank you so much, Jen, for a really thought-provoking conversation. Thanks for taking the time to spend time with us. For everybody else, and I hope you as well, hope you'll join us for our seminar next week, March 8th. That will be Suresh Venkata Subramanian, who's a professor of computer science and data science at Brown University. But he recently finished an appointment as Assistant Director for Science and Justice in the White House Office of Science and Technology Policy in the US, where he helped to co-author the blueprint for an AI Bill of Rights. Suresh is going to be talking about algorithmic fairness and the impact of automated decision-making systems in society. So we'll expand our interdisciplinary conversation in that direction. And we really look forward to having you join us at that time. Thanks everybody for being here. And thanks, Jen.